Right Honorable Speaker, point number 3.1. The title is "The Bill is Misconceived." Right Honorable Speaker, the explanatory memorandum of the bill indicates that the intention of the bill is designed to address gaps in the provisions of other laws in Uganda. For example, the Penal Code Act, Cap 120. The explanatory memorandum further indicates that the Penal Code Act, Cap 120, has no comprehensive provisions catering for anti-homosexuality, since according to the bill, the Penal Code Act focuses on unnatural offenses under Section 145 and lacks provisions for penalizing the procurement, promotion, dissemination of literature and other pornographic materials concerning the offense of homosexuality. Right Honorable Speaker, this is not a factual statement, since we all know that homosexuality is an offense proscribed in Section 140 of the Penal Code Act, which we reproduce here below. Section 145. 145, the subtitle is Unnatural Offenses. Any person who, A, has canon knowledge of any person against the order of nature, B, has canon knowledge of an animal, or C, permits a male person to have canon knowledge of him or her against the order of nature, commits an offense, and is liable on conviction to imprisonment for life. The above section, Right Honorable Speaker, please protect me from the Honorable both of both. The above section specifically prohibits and punishes. Right Honorable Speaker, the above section specifically prohibits and punishes conduct of a person who has canon knowledge of any person against the order of nature, and the conduct of a person who permits a male person to have canon knowledge of him or her against the order of nature. This provision has been in our penal code for a millennia. Right Honorable Speaker, the explanatory memorandum also indicates that the penal code focuses on unnatural offenses under Section 145 and lacks provisions for penalizing the procurement, promotion, disseminating literature and other pornographic materials concerning the offense of homosexuality. This is also not true, since the provisions of Section 145 criminalize, in addition to homosexuality, sexual acts between animals and human beings. In addition, the Penal Code Act has comprehensive provisions that deal with penalizing the procurement, promotion, disseminating literature and other pornographic materials concerning the offenses of homosexuality under the general prohibition on conspiracies in Chapter 16 of the Penal Code Act, Cap 120. Conspiracy to commit felony, conspiracy to commit misdemeanor, and other conspiracies. For instance, Right Honorable Speaker, courts in the case of Nabagesera and 3 others versus the Attorney General and another, miscellaneous cause number 33 of 2012, recognized that the actions of the petitioners in organizing a workshop advocating for normalization of minority rights in Uganda was a conspiracy, since it engaged in direct or indirect promotion of same-sex practices, which is prohibited under the Penal Code Act. This means that acts that tend to promote homosexuality can be dealt with conclusively under the Penal Code Act. We, the minority, surmise, therefore, that this bill was introduced under the reasonable but mistaken belief that the Penal Code Act is not sufficient to deal with matters related to homosexuality. It was introduced during a time when anti-homosexual sentiments have been whipped up across the country and is not based on any factual or evidential value to show incidents of homosexuality have increased and require additional legislation. Right Honorable Speaker, according to the annual crime policy reports, incidents of homosexuality have been reducing in Uganda. Right Honorable Speaker, in 2017, the police in Uganda recorded a total of 120 cases of homosexuality. In 2018, the number recorded was 100. 2019, 103. In 79 cases were reported in 2020, and 80 cases were reported in 2021. 2022 recorded 83. This means that the legislative interventions sought are not backed by any evidence of increase in this particular crime.
Order, Madam Speaker. Order.
3.2.
Order, Madam Speaker.
Can you finish?
Order.
3.2.
Order, Madam Speaker.
3.2, Right Honorable Speaker. Criminalization of appearance of a person. The second point of dissent is that the bill in its current form creates a penal sanctions against a person merely based on appearance, thereby attempting to reverse the decision in the court case of Kasha Jacqueline versus Rolling Stone Limited and another, miscellaneous cause 163 of 2010. Right Honorable Speaker, the minority are aware that clause 2(1)(d) of the bill proposes to declare as acts of homosexuality a person who holds out as a lesbian, gay, transgender, a queer, or any other sexual or gender identity that is contrary to the binary category of male and female. This provision has the effect of criminalizing the persons who identify as lesbians, gay, transgender, queer, or any other sexual or gender identity that is contrary to the binary categories of male and female, without such persons committing any offense under the laws of Uganda. The committee was also informed by the Uganda Medical Association that in Uganda there are rare biological cases affecting the genes that code for unusual expression of physical phenotypic expressions associated with genital organs. These include Klinefelter syndrome and random genetic occurrence.
Clark, can I have more chairs inside for members? Can you summarize?
Right Honorable Speaker, the third point of contention at 3.3, and I'm trying to run through a rather long report, 11 pages.
No, you take your time.
I take my time.
Thank you.
Thank you. Thank you, Right Honorable Speaker. Right Honorable Speaker, the DPP cautioned the committee about clauses 1(2)(d), which seeks to punish a person based on appearance, and reasoned that if a person holds out as a thief, he cannot possibly be punished for being a thief until he commits the crime of theft. The minority are aware that the following police conduct, the police conduct in Victor Mukasa, I beg your pardon, Right Honorable Speaker, the minority are concerned that the police has been arresting people based on their appearance, as was found in the case of Victor Mukasa and another versus the Attorney General. High Court Miscellaneous Cause number 24 of 2006, where the plaintiff in that case was arrested by police based on appearance and without having committed any offense, and taken to the police to determine his sexuality. The minority are aware that following police conduct in Victor Mukasa, Supra, court guided in the case of Kasha, Jacqueline versus Rolling Stone, and another, Miscellaneous Clause 163 of 2010, that, and I quote, the scope of Section 145 of the Penal Code is narrower than gayism generally. That one has to commit an offense under Section 145 to be regarded as a criminal. This decision means that being or appearing as a person belonging to LGBTQ plus person is not in itself an offense until the person commits any of the offenses prohibited under our laws. This means that a person cannot be criminalized, but the conduct of that person can be. Right, Honorable Speaker, the third point of dissent is duplication of provisions in the Penal Code Act. The minority note that the majority of the stakeholders who appeared before the committee pointed out that the bill introduces nothing of practical value, but merely reproduces provisions that already exist in other laws. Whereas the majority of the clauses in the bill are unconstitutional, the rest are redundant, and they become useless once the unconstitutional provisions are removed. The redundant clauses include Clause 5.2, 4, Clause 7, 9, 10, 11, 13, 15, 16, and 17. The bill is a duplication of the provisions that already exist under the Penal Code Act and is therefore unnecessary. The DPP also objected to the bill on grounds that the proposals contained in the bill should be introduced if they are found relevant in the Penal Code rather than being introduced in the proposed bill. The Attorney General advised the committee and pointed out a number of provisions that are already prescribed in our laws, making the bill redundant and of no legislative value. The minority find the following provisions redundant. Clause 1 defines matters that are already provided in other laws, including the Penal Code Act. Clause 1 on the offense of homosexuality is provided for in Section 145 of the Penal Code Act. Clause 2 of the offense of aggravated homosexuality can be prevented in Section 129 of the Penal Code Act on the offense of defilement. Clause 4 is already prescribed in Clause 146 of the Penal Code Act. Clause 7 is well entrenched in Article 28 of the Constitution, which gives judicial discretion to a court or a tribunal to exclude the press or the public from all or any proceedings before it for the reasons of morality, public order, or national security, as may be in a free and democratic society. Clause 8 is already provided for in Section 19(1)(c) of the Penal Code Act. Clause 9 of the bill exists in Chapter 16 of the Penal Code Act. Clause 11 is already provided for under Section 134 of the Penal Code Act. Clause 13 is redundant since Article 31(2) specifically bans same-sex marriages, and the Marriage Act defines a marriage and does not include same-sex marriage. Clause 16 is redundant. There exists a law to regulate extraditions from and to Uganda, and that law is the Extradition Act, Cap 117. The minority are aware that the provisions of the bill, once passed into law, will complicate the prosecution of offenses under the Penal Code Act. The committee was cautioned by the Attorney General that there's nothing that prevents Parliament from enacting laws or indeed improving on existing provisions of the law to meet emerging challenges in or of the society, as long as Parliament cautions itself against duplication of provisions in other laws. Our last point of dissent, Right Honourable Speaker, our second last point of dissent, the constitutionality of the bill. The bill makes provisions for matters which infringe the Constitution of the Republic of Uganda 1995, including Article 27 on the right to privacy, Article 24 and 44A relating to non-derogable right to freedom from inhuman and degrading treatment as protected under Articles 24 and 44A, Article 21 of the Constitution on the right against discrimination. The bill goes beyond the limitations envisaged in Article 43 of the Constitution, and some provisions contravene the principle of legality prescribed in Article 28(12) of the Constitution. Right Honourable Speaker, not only does the bill contravene the provisions of the Constitution of the Republic of Uganda, it also contravenes established international and regional human rights standards, as it unfairly limits the fundamental rights of the LGBTQ+ persons. This criminalization, Right Honourable Speaker, denies them equal protection under the law owing to the harsh and differential treatment they receive based on their sexual orientation and criminalization of the same. The provisions, Right Honourable Speaker, the provisions that further infringe the Constitution also include Clause 3(1)(b) and (c), which make the offense of homosexuality aggravated when the offender is a person living with HIV and when the victim is a person with disability, and we propose that that would violate Article 21 of the Constitution because it's discriminatory. The discrimination on the basis of HIV status and being a person living with disability. These provisions perpetuate the stereotype that people living with HIV cannot engage in safe adult-to-adult sex, that people with disabilities are eminently victims in human relationships. B, Clause 5(1), Right Honourable Speaker.
Honourable members, please respect the member.
Clause 5(1), which provides that a victim of homosexuality shall not be penalized for any crime committed as a direct result of his or her involvement in homosexuality, combined with the definition of victim in Clause 1 as including a person who is involved in homosexual activities against his or her own will, introduces the homosexual panic defense, which essentially gives the victims a leeway to harm suspected LGBT persons and get away scot-free, thereby contravening the presumption of innocence guaranteed under Article 28(3)(a) of the Constitution. C, Clauses 1, 2(1)(d), 3(1)(b), E, F, 4(1) and 8, in as far as they define touching as constituting the offense of homosexuality, aggravated homosexuality, attempt to commit homosexuality, and aiding and abetting homosexuality, respectively, would violate the principle of legality under Article 28(12) of the Constitution. This provision requires that all criminal offenses be properly defined and is part of the non-derogable right to a fair hearing protected under Article 28 and Article 44C of the Constitution. Court has declared provisions of laws that are incapable of exact definition unconstitutional. It's therefore the position of the minority that the provisions in the bill, if passed into law, infringe the rights of Ugandans, specifically the rights and freedoms of expression, association, liberty, privacy, equality and freedom from discrimination, inhuman and degrading treatment, the right to a fair hearing, and finds that if Parliament enacts this into law, it will be unconstitutional. 3.5. Right Honorable Speaker, some of the we also argue that the bill reverses the gains registered in the fight against gender-based violence, especially against women and girls. Some of the clauses of the bill.
Honorable members, can we
Right Honorable Speaker.
give him time to finish?
Some of the clauses of the bill reverse the gains registered in the fight against gender-based violence, especially of women and children. The bill in clauses 2 and 3 makes provisions for the offense of homosexuality and aggravated homosexuality. The provisions prescribe sanctions for 10 years against a person who infringes against the provisions of the bill. The minority has examined these provisions and finds them to infringe on sections 123, 129 of the Penal Code, which create the offenses of rape, and defilement respectively. These offenses prescribe varying sentences against persons who conduct themselves or herself in a manner that constitutes the offense, ranging from death to life imprisonment. The bill now proposes to make various indirect amendments to those provisions of the Penal Code by reducing the penalties for the same conduct that is prohibited under sections 123 and 129 of the Penal Code from death and life imprisonment to 10 years imprisonment. This makes the provisions regressive, affects the fight against gender-based violence against girls and women, and reverses the gains so far registered in the fight against rape and defilement. In conclusion, Right Honorable Speaker, the minority have examined the bill and are of the considered opinion that the bill is ill-conceived. It contains provisions that are unconstitutional. It reverses the gains registered in the fight against gender-based violence. It criminalizes individuals instead of conduct, and that contravenes all known legal norms. The bill does not introduce any value addition to the statute books and available legislative framework. In light of the above, the minority proposes A, that the spirit of the anti-homosexuality bill guides the enrichment of a comprehensive, non-discriminatory sexual offences bill. B, that the proposals contained in the bill should be presented to the Law Reform Commission to study and advise government on the possible reforms of sexual offences laws. C, that government should introduce legislation and a framework for the provision of rehabilitation of victims of sexual and gender-based violence. D, that the existing legislation be amended to provide clarity where necessary. Right Honorable Speaker, I beg to report.
Thank you. Honorable members, I want to thank the minority member, and I will give time. Honorable members, once we open the debate, we are going to structure the debate in this way. Those who are not in favor of the bill will also get up and speak, like he has spoken. We start with them. Then we will know who is who.
Madam Speaker, with all due respect, Madam Speaker, with all due respect, I've rose on the point of procedure that would proceed very well, since we have a very capable doctor here at Parliament to go and examine Honorable Fox Odoi whether he is by homosexuality, so that we discuss knowing the gender of Honorable Fox Odoi. Because you cannot write a minority report and you have nobody to support. Therefore, Madam Speaker,
Honorable members,
I don't know whether we are proceeding well without we knowing the gender of Honorable Fox Odoi, because he said that the police sometimes arrests people because of appearance. Honorable Fox Odoi might be having beards, but he's a woman or he's a bisexual.
Honorable members,
Therefore we need him to be really examined to know.
Honorable members, I have never got any report about Honorable Fox Odoi's Honorable members, let's move with the bill. Let's debate. You know, Fox Odoi has his own right, in his own, and I'm aware he's a polygamist.
I thank you, Madam.
Thank you, Father Nen. Father Nen.
Thank you, Right Honorable Speaker. I stand here to support the bill. Right Honorable Speaker, when I look at you and the honorable ladies in this house, there is no reason for a man to run after a man for sex. Right Honorable Speaker, Right Honorable Speaker. Right Honorable Speaker.
Order.
Right Honorable Speaker.
Honorable members. Honorable members.
Right Honorable Speaker. There is nothing so sweet and so good for a man more than a woman. And for that reason, there should be no reason for a man to run after a man. Right Honorable Speaker,
Bring the minister.
I implore
Honorable members. Honorable members. Can you give Father time to speak?
Thank you. Thank you. Right Honorable Speaker. Right Honorable Speaker. The essence of humanity is preservation of life. And this can only be guaranteed through the procreation. Homosexuality has no essence. It is just a mere romantic and sexual attraction towards a person of the same sex. Right Honorable Speaker, it should be put on record that Honorable Fox Odoi does not have his children here in this country. All his family are in UK. And that's why he's supporting this bill. That's why he's against this bill. And I want to conclude by saying, in the book of Genesis, during the floods, during the Noah's time, it is recorded that all the creatures went into the ark, into the Noah's ark, in pairs. And there was no record that homosexuals also entered into the ark of Noah. And for that reason, I implore that honorable colleagues, we vote yes, we protect our integrity, we protect our sovereignty as a nation, we protect our family values, we protect our children.
Thank you.
Thank you.
Thank you. Honorable members, I want to guide you. When you're debating, don't attack the personality of a fox. Let's look at Tinker.
Thank you very much, Right Honorable Speaker. I want to thank you for your guidance that this bill is not about...
Honorable members, please. There is one house.
This bill is not about Honorable Fox Odoi. Honorable Fox Odoi is only attempting to be consistent with what he stood for in the Constitutional Court. I will persuade him as a father and a husband of two beautiful ladies to abandon what he stood for by then and know that the position of Ugandans has changed. And it is that all Ugandans are against homosexuality. Yes. Right Honorable Speaker, the major argument that persuaded the Constitutional Court to nullify the work that we had done by then was the issue of quorum. This has been cured. I am sure and certain that all the arguments of the for homosexuality, they will fall flat even when they go to court. Right Honorable Speaker, they based themselves on Article 27, right to privacy. Right Honorable Speaker, I submit that Article 44 of the Constitution, that right is derogable. You cannot have that argument on issues that are seriously affecting and torturing our children. You had the submission of the Honorable Minister from Soroti, the former Arrow boy. Homosexuality, where they are practicing it in schools, is actually torturing, rapturing. Rapture is an act of torture. It is against the constitution of this land. Right Honorable Speaker, they will submit that they are arguing under the protection of minority groups. They will argue that they want affirmative action. Right Honorable Speaker, Professor Mbiti, in his book, African Traditions and Institutions, he says, we should only and only promote African traditions that add value to our culture. In this matter, that is so foreign, I don't find anything that we are promoting in abiding, in being persuaded by our honorable colleague.
Thank you. Honorable OO. Let's listen. Members, let's listen.
Thank you, Right Honorable Speaker and honorable colleagues. This bill,
honorable members, listen and understand the bill.
This bill restores hope in Uganda. This bill is a wake-up call that the penal code that we've had for the last 100 years is obsolete. This bill, in effect, has been recognized by the Minority Report when the mover of the Minority Report, my uncle, for the record, I risk to be cast But now that I have had enough number of children, it may not cause me not to have children. But he recognized that Section 145 of the Penal Code has, well,
Yes.
Section 145 of the Penal Code.
Yes, Samuju.
Madam Speaker, this bill is a moral issue. The suspects of Mabati
Honorable Samuju. Honorable Samuju. Honorable Samuju, please sit. Honorable members, as legislators, let's mean business when we are doing something. The issue of Mabati will also come. Let's first clear this issue. Eh? You cannot equate homosexuality with Mabati.
Thank you. I know
Honorable
that,
members.
I know that Honorable Semujo is missing me, and he wanted me to say something about Mabati, but as you've rightly guided, that that will also come and have its own way. Let me talk about what will affect my children and my great-grandchildren. Mabati can be here today, and tomorrow the storm will break it down. But the issue of morality that your honorable members will all know is a matter that guides our society. The penal code that we have came in 1923, so it's about 100 years old. So, as a student, a former student, and now a scholar nearly on matters of jurisprudence, on sociological theory of law, that law grows with society. I can tell you that what was not then, it can now be. And what is not now, it will one time be. So, honorable members, we need to guide ourselves on this without sentiments, without emotions, and look at the penal code as it is. Is it clearly protecting the values that our forefathers put in 1923? If the answer is the negative, laws can be amended. In fact, the minority report is silent on whether this law is not necessary per se. They are only saying that it already exists. But when a law exists and it's not effective, the minority also gave the statistics of number of cases, and you see that the number were there very minimum. This is a good case from the minority report to make a legislation that will work for all. And I believe that this bill is in the right direction without any other consideration. If we are looking into the future, we should be able to support this bill. And I stand here to support the bill with the view that laws are made for us. The ones that the minority is looking for, they should give Uganda another 100 years. Maybe it will be acceptable. And I'm using the word maybe. And I'm using the word maybe because I know what I'm saying. Because the law grows with society. If by that time the majority will say this is what they want, it should go. But now, what we are saying is that let's go with what will guide our society and regulate our conduct. What is in the penal code is not sufficient. That is why there is a need for us to have this legislation.
Thank you.
And I don't only stand here as a minister, I stand here as a member of parliament from West Budama Central, who has 4 lovely sons and 2 beautiful daughters.
Oduru.